Yeah, I'm also because we decided to switch up to find out a bit more about now.
Good evening, everyone. Welcome to the University of Sussex Junior Moot Competition Finals for 2023. My name is Cashin. I'm one of the co-organizers. The other one is Olivia Payne, who will be joining us shortly with our judges. Now, it is typical decorum when you're in a courtroom that when the judges enter, all rise, which means everyone will stand up until they are seated, and then you may all take a seat again. So the way that this is going to work is there'll be 20-minute intervals for everybody speaking as the delegates here. And after that, there'll be a moment for some delegation where the judges will step out, discuss, and kind of go over who they think should be deserving to have their names put on this glorious trophy over here. In that time, refreshments will be open in the seminar room across, and you are all welcome to them. Now, before we begin, I will give you this. Everybody ready?
Okay, so please rise, everyone.
Before we start, sorry. In terms of the timing, is someone going to help us with the times?
Absolutely.
You sure? Otherwise, I can. Is that all right?
Absolutely.
Thank you. Good afternoon, ladies and gentlemen. So, we have Miss Kane, Mr. Capisanto. Afternoon. And for the respondents, Mr. how do I pronounce it? Avabak?
Yes, that's correct.
And Mr. Barry. Afternoon. Ooh. So we are here sitting in the Supreme Court to consider the application, Ms. Kane and Mr. Capisanto. Your application? Yes?
Yes.
Do you want to begin?
Good evening. May I ask how the bench would like to be addressed?
Well, we're in the Supreme Court. So, my lord and lady, thank you very much.
May it please your lord and ladyships, I, Miss Isabella Kane, along with my co-counsel, Mr. Kane Capper-Sandon, will be representing the appellant, Mr. Peter Wolfe. And my learned friends, Mr. Ron Averbuck and Mr. William Farrell, are representing the respondent, Upon Avonshire Fire and Mountain Rescue Authority. Would your lord and ladyship care for a summary of the facts of this case?
Just briefly, thank you very much.
Sure. Peter Wolfe and Marshall Cryer, the closest of friends, also known as the Crays, are extremely proficient climbers and have mastered the difficult climbs where they live in the very close-knit community of Upon Avonshire. In the summer of 2016, the Fire and Mountain Rescue Authority was called by tourists 10 times in response to their antics. In August 2016, the Crays were climbing Big Boy to practice their routine when Marshall got buried by a rock slide, leaving him screaming and blood everywhere. Peter called the Mountain Authority, who took his call but did not arrive for 4 hours. Peter developed a psychiatric illness from watching Marshall suffer and brought a claim against the Mountain Authority for negligence. Focusing on the first ground of appeal, it is submitted that the respondent did owe Mr. Wolfe a duty of care when applying the established principle for the duty of care for the ambulance services, and that there was an assumed responsibility for Mr. Wolfe, as well as liability for positive acts that negligently increase harm suffered. If it pleases your lord and ladyships, I'll now begin my first submission.
Yes, thank you.
There is an established duty of care for ambulance services, distinguishing it from public services that should be applied to the respondent in this case. If I may ask your lord and ladyship to direct your attention to the case of Kent and Griffiths reported in the Queen's Bench Division Law Report in 2001 at page 36 and found on page 8 of the appellant bundle.
All right, if you just pause there so we can find it.
Absolutely.
Yeah, thank you.
May I ask your lord and ladyship to dispense a formal citation?
Yes.
Thank you. Would
And
your
in
lord-
fact, well, if you did the formal citation for the first one, and then we can dispense thereafter.
Going forward, yes.
Yes.
Thank you. And would your Lord and Ladyship care for a summary of the facts of this case?
Not at this moment in time, thank you.
A key principle from this case is that as an extension of the health service, ambulances are held to have a duty of care to respond to accepted callers, unlike other public services that do not owe a duty of care to the general public. If I may draw your Lord and Ladyship's attention to page 38 of the case and page 8 of the appellant bundle. It states and is highlighted, the ambulance service should be regarded as part of the health service.
Sorry, just pause. You said page...
Page 8 of the appellant bundle, and page would be 36 of the case.
Yes. And which paragraph?
I believe it's the second or the first highlighted section. Second highlighted section in F.
F, right. Sorry, carry on.
No problem. The ambulance service should be regarded as part of the health service, where a duty of care to patients normally exists, rather than providing services equivalent to those rendered by the police or fire service when responding to a 999 telephone call. Turning to our current case, the respondent should be regarded as and held to the same duty level as the ambulance service, as they provided services and care more in line with that of an ambulance than those of a fire or police services. The respondent should be viewed as a hybrid entity, given that although it is labeled as a fire and rescue authority, they also provide emergent mountainside medical response.
So help us with the case law where it says that. Is there a precedent to help us?
Well, within the case referring to ambulance versus fire, when you're providing a service that's more in line with that of the ambulance, would it not be reasonable to compare that service to the duty that would be held of an actual ambulance?
I'm asking you exactly that we can see that this case refers to the ambulance.
Yes.
You're making a distinction about the fire and rescue service, aren't you?
Correct.
And I'm just wondering, is there precedent to assess this, or are you inviting us to consider this as a separate entity?
Yes, there's precedent, and I could refer to you in this case as well as in my second submission. I also refer to an incident where the police service is held to the same duty as that of an ambulance service, given that it was responding in a medical capacity.
All right, well perhaps I just need to be a bit patient.
If you would like me to refer to that.
No, it's fine, carry on, thank you very much.
Thank you. In this current case, given that the nature of the response was of a medical nature, given that Mr. Cryer and Mr. Wolf had potential injuries, it's reasonable to establish that the respondent owed a duty of care in line with that expected of a medical professional, like an ambulance service. If I may draw your Lord and Ladyship's attention to page 43 of the case and page 15 of the appellant bundle.
All right, so just bear with this moment while we get
Not a
to it,
problem.
thank you.
Sorry, which page was that?
Page 15 of the appellant bundle.
And of case?
43.
And which paragraph? I think it might be B. Is it the highlighted one?
Yes, it's the highlighted section,
Right.
yeah. It states the duty to fight fires remains throughout a duty owed to the public at large. By contrast, once a call to an ambulance service has been accepted, the service is dealing with a named individual upon whom the duty becomes focused. While generally public authorities are not liable to individuals, however, unlike the fire and police service, where they have no duty to respond, in our current case, once the call operator accepted Mr. Wolf's call, which was done so when they indicated that the help he deserved would be sent, a duty between the medical response service and Mr. Wolf was formed. In accepting Mr. Wolf's call, through the indication that help would be sent, the respondent owed Mr. Wolf a duty to respond.
Well, let's just pause and think about that. Remind us again exactly what they say.
The wording is that the help he deserved would be sent.
Well, yeah, Peter, we'll respond to this emergency with the same urgency all your other calls deserved.
Correct, and I believe it continues to go on after he emphasized that this was true. They said, do not worry, the help you deserve will be sent.
It's not to worry, the help he deserved
Yes.
would be sent.
Correct.
So one reading of that is, as you say, that this is an affirmation that they're going to send the ambulance service. But another reading, is it not, is that given that there were 10 or so prank calls previously, and they turned up and there was no actual emergency, when they say we'll treat this as all of your other calls deserved, are they not saying the other ones deserve nothing, therefore we're not going to send one?
Well, that would be one interpretation.
Yes.
It is submitted that in the previous instances, it was never one of the Crays or the boys that actually did the submitted the call to 999. The calls were always submitted by tourists. So in this instance, it would be reasonable to believe or to treat this call as legitimate, given that Mr. Wolf or Mr. Cryer themselves had never called the service asking for help. It was always done by others.
Yes, so as far as you're concerned, the response from the emergency service was affirmation that they were going to send someone.
Correct.
Yes, all right, carry on.
Lord Wolf also addresses in his judgment that the issue of resource allocation and fairness, considering the demand and availability for ambulances to respond. So unless the demand for ambulances outweighs the available units, it's negligent of the ambulance service to arrive in an untimely and unreasonable manner. If I may draw your Lord and Ladyship's attention to page 54 of the case and page 28 of the appellant bundle.
All right, so just pause just so we'll find that. Yes?
It states that the fact that it was a person who foreseeably would suffer further injuries by a delay in providing an ambulance when there was no reason why it should not be provided, it is important in establishing the necessary proximity and thus duty of care in this case. This is particularly applicable in our current case, as it can be considered foreseeable that Mr. Wolf would suffer further harm as a prolonged witness to a suffering close friend due to the negligent delay in arrival of a medical response team. Given that a team was available to respond to Mr. Wolf's call at the time, there's no reasonable justification for the medical team's late arrival on site. This establishes the necessary foreseeability and proximity in our current case between Mr. Wolf and the respondent. Considering that the respondent should be held to the established duty of care required for ambulances, since they perform like functions, the respondent owed Mr. Wolf a duty to respond to his accepted emergency call in a timely manner. If it pleases your Lord and Ladyships, I'll now begin my second submission.
Yes, go ahead, thank you.
The respondent assumed responsibility over Mr. Wolf through the assurances made by the operator, which Mr. Wolf relied upon, which made rise for a duty of care to be owed. If I may ask your Lord and Ladyships to direct your attention to the case of Shrat and Chief Constable of Greater Manchester, found on page 27 of the appellant bundle. Would your Lord and Ladyships care for a summary of the facts?
Would you? Anyone?
Just very briefly, please.
Sure. A mother phoned 999 concerned about her daughter who was at risk of taking her own life. The call operator assured the mother help would be sent. The call was given high priority, which was subsequently downgraded. The officers attended the daughter's house 3 hours after the initial call, but there was no response. They attended again at 8 the following morning and found the daughter deceased. The mother successfully claimed there was a duty of care based on the established assumed responsibility over the daughter's welfare.
Doesn't that distinguish from this case, though, where there was no injury at all? I mean, in the case you're referring to, a child died.
Correct.
They're both serious. Where in this case, in fact, there was no injury, was there?
Well, at the time of the 999, it's submitted that at the time of the 999 call, it was unknown the extent of the injuries. Given that there was blood everywhere, it would be likely for the caller to assume that there was an emergency situation unfolding.
I just wanted to ask about the blood because my understanding, and my sister and brother judge might think I'm wrong about this, that my understanding was that there was no harm to him, that he suffered no injury.
Correct.
So where was the blood?
That is a great question, which it's submitted that based off of the information that Mr. Wolf had at the time of the call and that he did see blood, given that it is in the facts of this case, that it was reasonable for him to assume that there was a serious accident unfolding, even though there was no harm in the end once it was resolved.
So we don't know where the blood was from?
Correct.
All right. Was it his friend pranking further?
It would be unlike.
Do you know that?
It is submitted that is uncertain.
That's fine. If you don't know, it's better to say.
I'm
All right,
sorry.
thank you. Carry on.
Yeah. The key principle from this case is that when assurances are made by a 999 operator, and they are relied upon, there is an assumption of responsibility which makes rise for a duty of care to be formed. And I will preface, while this case is from the High Court and may not at present be legally binding, it is submitted for your consideration as it is nonetheless persuasive through its application of the principle in relation to the facts. If I may direct your Lordship's attention to paragraph 74 of the case found on page 48 of the appellant bundle.
Thank you very much.
It states, although the police handler did not state any specific time as to when the police would arrive, the clear messaging given to the mother was twofold, namely that the help for her daughter was going to be dispatched to her house promptly and quickly, and secondly that she should leave with the police any need for her daughter to get to the hospital. Furthermore, found in paragraph 80 of the case on page 50 of the appellant bundle,
Yes, thank you.
it states that there was sufficient reliance on the assurances given to bring this case within the assumption of responsibility exception. Turning to our current case, the call operator similarly did not give a specific time to Mr. Wolf as to when help would arrive. The operator did, however, give assurances that help would be coming when they told Mr. Wolf not to worry, the help he deserved would be sent. To Mr. Wolf, who stressed to the operator the gravity and legitimacy of the situation, it would be reasonable for him to believe that the help he deserved would match the level of urgency he portrayed.
Sorry to interrupt you. Can you not, deserved surely is one of those words which can have different interpretations, and is that not potentially going to cause you problems in your submission?
Well, it is submitted, there are different interpretations of the word deserved. It is submitted on behalf of Mr. Wolf, his interpretation, and that it was of high urgency, and in him portraying the legitimacy of the situation, it's reasonable for him to assume that the operator on the other end of the call would accept and understand that urgency that he's being portrayed, given the state that he was in of an emergency, seeing his best friend in an accident, and any shock that might be occurring at the time due to the incident that he's witnessing.
So you're asking us to accept that the response from the call handler to Wolf was of the same level of gravitas, if you like, as in the authority that you're currently.
It is submitted, yes. The words and actions of the respondent call operator, through the use of assurances, which were then relied upon by Mr. Wolf, which is shown by him waiting several hours before attempting to call for help again, that the respondent did form a duty of care towards all those intertwined and involved in the emergency services incident, all those involved in the incident. And the respondent in this case should therefore owe Mr. Wolf a duty of care as an individual involved in the emergency, since he relied on the assurances that they provided to him. And if it pleases your Lord and Ladyship, I'll now begin my third submission. The respondent, through their negligent positive act of delaying the arrival of the medical team, breached their duty to Mr. Wolf by making the situation worse. If I may ask your Lord and Ladyship to direct your attention to the case of Capital and Counties and Hampshire County Council, found on page 54 of the appellant bundle. Would your Lord and Ladyship care for a summary of the facts?
No, thank you.
Sorry, can you just give me the reference again, please?
Found on page 54 of the bundle.
Thank you.
The important principle drawing from this case is that the public authorities have a duty to not increase the damage or harm caused through their own positive actions. While this case does state that fire and police services do not have a duty to answer calls for help, it was established in my first submission that the respondent in this case should owe a duty of care to respond in a manner comparable to that of the ambulance service, rather than that of police and fire. However, this duty to not worsen a situation through positive acts can be applicable to all public authorities. If I may direct your Lord and Ladyship's attention to page 1032 of the case and page 82 of the appellant bundle. states, but it seems to us that there is no difference in principle if by some positive negligent act the rescuer service substantially increases the risk, he is thereby creating a fresh danger, albeit of the same kind or of the same nature. In our current case, the call operator's positive act was the delaying of the arrival of the medical team at the scene by 4 hours when units would have been available to respond at the time of the initial request by Mr. Wolf. While the respondent's action of not diligently submitting the request may appear at first glance as an omission, the respondent must have eventually passed on the request, as the respondent medical team did eventually show up at the scene. The call operator's deliberate act of delaying the request directly led to the psychiatric harm suffered by Mr. Wolf, as if the response team did arrive promptly, Mr. Wolf would not have had to witness his close friend's suffering. This is a direct breach of the respondent's duty of care not to cause further harm. Okay. If I may direct your Lord and Ladyship's attention to page 1051 of the case and page 101 of the appellant bundle.
Thank you. Carry on, thank you.
It states that this is a very high threshold in establishing negligence, namely that it must be established that the error was one that no reasonably well-informed and competent fireman could have made. In this case, it is unlikely that the reasonable call operator would deliberately delay the dispatch of emergency services purposely. There is nothing to support that this delay was caused by anything other than the operator's own negligence. As a reasonable call operator, one would suppose that they treat every call equally and view them as legitimate, unless given good reason to think otherwise.
But in that case, in this case, were they not given good reason? Because there were so many prank calls, I appreciate from members of the public, but about these two individuals, that would it not surely give good cause for a reasonable operator to not send?
Your Ladyship, it is submitted that as the community in the facts of the case stated that it's a very tight-knit community where the residents are very well known to each other, yes, it would be reasonable for the operator to be aware of the pranks. But again, it would be reasonable for the operator to also know that the boys themselves had never called on behalf of their pranks.
So they're well known for being pranksters?
They're well known for being pranksters, however, given the nature of their prank, where it was always Mr. Crier, who was one dangling, and Mr. Wolf, who was there taunting on the crowds, one would know that Mr. Wolf was not in a position was always in a position where he could have called, but he did not call.
Okay.
And so therefore it would be reasonable to conclude that if the Crays themselves were calling, that it would then be for a legitimate reason.
Just on that point very quickly, noting, is it not known that these boys had a history of not being respectful to the authorities? So surely the call operator again would have a reasonable ground for believing that potentially they could be pulling their own prank this time.
Well, that point is acknowledged. It is submitted that although of that past, even with that past history, every 999 call should be treated with the same level of legitimacy and the same level of vigilance, regardless of past history, in order to ensure the service is operating at the highest level of service that it can provide to individuals.
Does that not come down to whether they consider there's an urgency?
Yes, it is submitted that urgency is a key factor.
Yes. So
in
if you don't think it's urgent, sorry, we'll just I've been really interventionist, so I'm sorry, so do just finish on this, if that's okay, finish your submissions. But.
Unless I can aid the court further, that concludes my submission on behalf of the lead appellant. And to finish answering your question, it is submitted that, could you just repeat the last part of your intervention?
No, it's fine, thank you, I'm sorry, because I asked lots and lots of questions, so thank you very much.
Not to worry, thank you so much.
So just one moment, we'll let someone over the gallery in.
No, it's fine. I just, in case you want to take a note.
Yes, please.
If it pleases your lord and ladyships, I'll begin my first submission.
Thank you.
It is submitted that the court below erred in finding that the appellant could not claim psychiatric injury on the grounds of it being too remote based on existing authorities. To refute this, the relationship between the appellant and Mr. Cryer, the appellant's temporal and spatial proximity to the incident, and the nature of the shock experienced by the appellant must all be examined. Firstly, it is submitted that the relationship between the appellant and Mr. Cryer was not too remote based on the facts. If I may direct your lord and ladyships to the case of Alcock and Chief Constable of South Yorkshire Police, which can be located from page 102 of the appellant bundle and continues until page 216.
Thank you. With that, thank you very much.
Would your lord and ladyships care for a summary of the facts?
No, thank you.
The case of Alcock is a well-respected authority on secondary victims in the context of psychiatric harm. A secondary victim being one that witnessed a horrifying event happen to a primary victim, but was not in danger themselves. In his judgment, Lord Ackner stated on page 404 of the law report and page 196 of the bundle.
So just bear with us while we get them. Thank you. You're not interested in what he says before that? There's a lot of things said before that.
There is many things before that.
Thanks.
He discusses which classes of people may be considered for a claim of psychiatric harm. And he states, whether the degree of love and affection in any given relationship, be it that of relative or friend, is such that the defendant, in the light of the plaintiff's proximity to the scene of the accident in time and space and its nature, should reasonably have foreseen the shock-induced psychiatric illness, has to be decided on a case-by-case basis. This binding precedent requires a heavy burden of proof, showing that the appellant and Mr. Cryer have a close tie of love and affection, as even the claimants in Alcock, who were blood-related to the primary victims of that case, did not succeed in their claims on account of failing to provide sufficient evidence of their affection. It can be seen from the facts located on page 3 of the appellant bundle that this requirement is fulfilled. The appellant and Mr. Cryer are described as inseparable, like brothers, and are often mistaken for twins, with their parents only half-jokingly claiming that they love each other more than their own biological families.
I think they get the cranks from their parents then.
These facts clearly demonstrate the pair's exceptional affection for one another, going above and beyond the affection of a typical friendship and becoming more akin to that of family. So it is submitted that it was reasonably foreseeable that the shocks experienced by the appellant would cause him psychiatric injury on account of this affection.
Just stopping you there very quickly, those are of course reports predominantly from third parties of the relationship to these boys, and as we all know, individual relationships can be quite private. Do we have any information before us from either party that confirms their relationship?
There is nothing in the facts that discusses their private relationship, but it is submitted that since this is this pair is very well known, the infamy of them, it would appear that since their public profile is that of fondness, that is a reasonable path to interpret that. So
in your view, is that high enough to reach the threshold you've just set out that isn't reached between blood relatives in the authority?
The reason why it was not reached by blood relatives was because that ruling was only made in that case.
so the barristers did not know that they had to prove it. The fact that there is such damning proof that they are so close in this instance suggests that they would surpass that bar.
Are we bound by Alcock?
Yes, it is the House of Lords judgment.
Okay.
If it pleases your Lord and Ladyship, I will begin the second submission.
Yes, thank you.
It is submitted that the appellant was sufficiently proximate in both time and space to the incident, such that he was able to witness both the initial incident and the immediate aftermath with his own senses. If I may direct your Lord and Ladyships to the case of McLaughlin and O'Brien, which can be located from pages 217 to 250 of the bundle.
Just give us very brief facts of that, please.
The fact of McLaughlin is that the claimant's family was involved in a road traffic accident at around 4 p.m. with a lorry driven by the first defendant and owned by the second defendant. The claimant, who was home at the time, was informed of the accident at around 6 p.m. by a neighbour who drove her to hospital to see her family. Upon arrival, she learned that her youngest daughter had been killed and witnessed the nature and extent of the injuries suffered by her husband and other children. The claimant alleged that the impact of what she'd heard and saw caused her severe shock, resulting in psychiatric illness, and brought an action in negligence against the defendants.
All right, so again, I asked your learned friend about this. These are two cases where death has occurred, whereas in this case, no injury to that first person. So how do you say that they relate so closely that you rely on them?
Well, firstly, I go into, in my third submission, the relationship between the actual harm or not, as the case may be.
All right, maybe I'll need some.
However, it's okay.
Thanks.
The precedent is what I'm relying on in referring to McLaughlin, referring to this aftermath doctrine that is referenced.
Yes. All right.
The case of McLaughlin is established that witnessing the immediate aftermath of an incident can still qualify the secondary victim as being sufficiently proximate. In that case, the 2-hour gap between the incident and the shock was seen as temporally proximate because the appellant came upon the immediate aftermath in the form of witnessing the extent of her surviving family's injuries. The reasoning for this can be found in the highlighted quotations located on page 422 of the law report and page 229 of the bundle.
Yes, thank you.
It states, to insist on direct and immediate sight or hearing would be impractical and unjust, and that under what may be called the aftermath doctrine, one who from close proximity comes very soon upon the scene should not be excluded. In the fact of the present case, it can be seen that the initial incident was Mr. Cryer's fall from a great height, his blood-curdling scream reaching the appellant as he fell into the ravine called Devil's Drop. The primary victim was then, quote, completely buried by rubble, and the appellant raced down the ravine to help him.
If it helps you, in terms of proximity, if we take the facts as they are, there is close proximity. So perhaps it would be better to focus on the third limb, if that's right.
Of course. In which case I will, if it pleases your Lord and Ladyships, I will begin my final submission.
Thank you.
It is submitted that the final requirement, that the psychiatric injury must be caused by a sudden shock, is also fulfilled. Returning to the case of Alcock, shock is defined by Lord Ackner on page 401 of the law report and page 193 of the bundle.
Just bear with us a moment. Yes, thank you.
It is described as the sudden appreciation by sight or sound of a horrifying event which violently agitates the mind. Lord Oliver expands upon what is considered horrifying on page 411 of the law report and page 203 of the bundle,
Yes, thank you.
stating that the psychiatric injury must have arisen from witnessing the death of, extreme danger to, or injury and discomfort suffered by the primary victim.
Is that paragraph G?
If you'll just allow a moment for me to double check. It is paragraph G.
Yes, thank you.
In the present case, it is submitted that the respondent negligently withholding rescue services from the primary victim placed him in extreme danger, and hearing the primary victim's terrified screams for 4 hours, all whilst there was blood everywhere, would certainly qualify the situation as discomfort suffered by the primary victim.
Well, you say that, but I come back to that. Sorry, go
No,
on.
no,
You say.
go on. No, you were probably saying something.
Go on, you go.
I mean, I'm still wondering how you can align the facts of the case before us with this authority. Injury suffered arose from witnessing the death of, so that doesn't apply. Extreme danger to,
Apologies.
or injury and discomfort suffered by the primary victim. Well, we know that he wasn't injured. He may have been uncomfortable, but it's injury and discomfort. Now, there is no injury. So are you simply relying on the extreme danger?
It could be both. The extreme danger of being trapped under rocks heavy enough that a professional rock climber cannot move them.
But we know he had no injury.
He had no injury, but
So
there
he
was
wasn't in extreme danger.
there was extreme danger for being trapped under there with no rescue. Since there was several calls over 4 hours, and there was no rescuers sent until the end of that 4 hours.
Sorry, I'm going to pull you up on that. There were several calls across 4 hours.
Yes.
There are not only 2 calls on the
There were
facts.
repeated calls, it says in the facts.
Yeah. Do you think that maybe he was pranking?
No.
So we have someone with blood curdling scream. We have reference to blood, but there was no blood. We have reference to extreme danger, but there was no injury. Is this not just another prank?
No, because neither party instigated the rock fall which cut the primary victim's rope, which caused him to fall a significant height down the ravine. If it was a prank, perhaps there would have been a way for the primary victim to escape.
Oh,
However,
you
as
don't
the
know that, do you?
no, I do not know that. However, the rocks were so heavy that there was no possibility of escaping.
What about the scenario that it didn't start off as a prank, but when he's under the rocks, it becomes a prank?
The screams are described as terrified,
Mm.
not necessarily in pain.
Mm.
Perhaps it is speculation, but a reasonable person might be terrified when trapped under unmovable rocks for 4 hours up a mountain.
If the screams in that case are from terror, then that kind of wipes out again those criteria, doesn't it?
It does not wipe out the extreme danger.
But being scared doesn't mean you're in extreme danger.
It
It's
is
your
submitted
personal
that the
response.
primary victim was scared of the extreme danger, of the prospect of being trapped up a mountain with no rescue.
Knowing that the fire and rescue service had come previously, every single time.
Yes,
Oh.
they had come every single time, and yet they had not come in the 4 hours of the repeated calls.
All right, carry on, thank you.
Yes. This, however, only partially satisfies the final requirement, as the shock experienced by the appellant must also be sudden. Before submitting the final case for the counsel for the appellant, it must first be brought to the bench's attention that while the following case is of the below court and is therefore not binding, the precedent it has set is a valuable tool in assessing the current state of the law on psychiatric injury for all lower courts and should be considered on those grounds. If I may direct your Lord and Ladyship's attention to the case of North Glamorgan NHS Trust and Walters, which can be located from page 251 of the bundle until page 262.
Thank you.
Would your Lord and Ladyships care for a summary of the facts?
No, thank you very much.
Glamorgan widened the limits of what could and could not be considered sudden. A 36-hour period with multiple shocks throughout it was deemed to fulfil the requirement in the case itself, as, to quote Lord Justice Ward at page 261 of the bundle, at paragraph 40,
Just bear with us a moment, thank you. Yes, thank you.
he states, each of these three events had their impact there and then. This is not a case of the gradual dawning of realization. Additionally, when referring to the case of McLaughlin and its discussion of proximity on page 257 of the bundle,
Which paragraph, please?
it is paragraph 23 at the very top of the page.
Thank you very much, that's very helpful.
It is stated, one looks at the totality of the circumstances which bring the claimant into proximity in both time and space to the accident. It seems to me, therefore, to be implicit in his judgment, read as a whole, that when he said at page 423, the shock must come through sight or hearing of the event or of its immediate aftermath, he was not intending to confine the event to a frozen moment in time. It is submitted that this outlook seen in Glamorgan should be applied to this case. The respondent's breach of duty was not gradually realised in the current case, nor can the shocking event be constrained to a frozen moment in time. The appellant eventually, not gradually, realised that the respondent's operator would not send the needed assistance. Over that period of 4 hours, the respondent's negligence caused several distinct, sudden shocks in the form of each individual denial. All the while, the appellant witnessed the horrifying scene of his closest friend crushed under rubble and screaming for help.
Well, he wasn't crushed.
He was trapped.
Yes.
Apologies.
No.
All these seamless events caused the appellant's psychiatric injury. This being so, there are no requirements that are left unfulfilled, thus demonstrating the appellant's claim is not too remote. For the reasons outlined by the counsel for the appellant, it is respectfully requested that you accept this appeal and reverse the decision made in the Court of Appeal Civil Division. Damages of £786,000 should be awarded to the appellant in response to finding that the respondent owed the appellant a duty of care and that neither the appellant's relationship with Mr. Cryer nor the appellant's psychiatric injury were too remote. Unless I may aid the court further, this concludes the submissions of the junior appellant.
Just bear with us a moment.
Grateful for your submissions. Just very briefly on the subject of damages there, that seems incredibly high for psychological injuries. Do you happen to have a breakdown of the lower courts at all?
While I do not have a specific breakdown that is presented in the facts, it was already awarded in the lower courts, and so while it is not presented to us here, one would rely on the judgments of the lower judges.
Great.
Thank you very much.
Thank you, Your Lord and Ladyship. Today, on behalf of the respondent, it is requested that here in the Supreme Court we dismiss the appeal on behalf of Mr. Wolf against the defendant in Pharma, which is the Uppenshire Fire and Mountain Rescue Association. Apologies. It will be shown on the facts that no duty of care can exist between the appellant and the respondent. And if it please your lawyer and ladyship, I will now begin with my first submission.
Yes, thank you.
If I may direct your attention to the case of Michael in Chief Constable, South Wales, begins on page 9 of the respondent's bundle.
Yes. Thank you.
Would your lord and ladyship care for a summary of the facts?
Yes, just a brief summary, thank you very much.
In brief, the deceased, Miss Michaels, was with her current partner at the time, where her ex-partner, with a history of aggressive behavior, stormed into her home, took away her current partner, threatening that he would then come back and come for her. Miss Michaels then phoned 999, requesting police protective services. The telephone handler, in speaking with the South Wales police officers, did not to them reference a possibility of death or murder, and as such, the South Wales officers reduced the priority of the call to a secondary level, which ensured that they would be there within 60 minutes rather than an immediate response. Unfortunately, upon their arrival, Ms. Michaels was found deceased. Now her family and her current partner bring a claim in negligence against the South Wales.
All right, thank you. Carry on. Thank you very much.
The issue in the Supreme Court, in the case of Michael, focused on whether the police owe a private law duty of care to those which have reached out to them directly.
Yes.
It was found by a majority of 5-2 that public policy would dictate that the public duties of officers is to uphold the king's peace, and such a public duty does not with it impose a private law duty which is owed to each individual who may request it.
But how does that sit when one looks at the duty for an ambulance service in comparison to, say, the police or the fire brigade? How does that sit with the mountain rescue? What do you say?
To clarify, your ladyship, you're asking that how is the mountain rescue made to be equivalent to the police in this example versus an ambulance?
Yes. I mean, where do you say it sits?
It's submitted that the mountain rescue is more equivalent to a fire brigade, as your ladyship pointed out, which is also to be equivalent to a police force.
No, I don't think I did point that out. Why, I'm asking you, why do you say it's more akin to those services than an ambulance service?
When discussing public services which deal with emergency situations, it is held that ambulances deal in the medical realm. And in terms of private law, they are held to the standards of medical professionals.
Is that right? Forgive me if I'm wrong. My understanding is that ambulance it's about individuals, whereas, for example, the fire and the police, it'd be multiple. Have I misunderstood that?
To my understanding, your ladyship, it's also specified by Lord Tolson in the judgment. Unfortunately, I cannot reference to the page and paragraph. However, Lord Tolson does make a distinction that ambulances, in providing their service, the individual, they may be subject to a different private law method of determining a duty of care.
Do mountain rescue service, do they not provide some form of medical care? Are they not trained? Is that not part of their purpose? Someone up a mountain, someone trapped, potentially crushed under rocks.
They are surely trained in basic medical profession.
So what's the difference?
It is submitted that ambulance professionals would be trained to a severely higher degree and equipped with far more equipment capable of handling much more desperate situations of medical attention.
All right, carry on, thank you.
In considering UFAMRA's capabilities and their response, it would be then followed that following the submission in Michael, there could be no duty of care to be found between the respondent and the appellant, Mr. Wolf. This is largely due to the idea that foreseeability alone was not sufficient to determine that the respondent should have been aware that a duty of care need be owed, and as such, there cannot be established a duty of care. When discussing foreseeability to not be sufficient in and of itself, Lord Tolson, in the case of Michael, specified that there needs to be a special circumstance in addition to the foreseeability that a duty of care would need to be owed. When dealing with cases which address police and emergency services arriving on scene, there needs to either be proximity, a special relationship, or an assumption of responsibility. On the facts, it can be observed that there was none of the three available to Mr. Wolfe when he made his initial phone call.
Why do you say that?
In dealing with the assumption of responsibility, it is made clear on the facts that the phone operator, in a rather unprofessional manner, dictated to him that he would receive the help he deserved. And in following with the facts which had been conducted on his own behalf, it would be easy to interpret that he deserved no help at the time.
Or you heard the submissions on behalf of your learning friends that the fact that they'd never made the calls before, that in fact the operator could very much read this into that there was an emergency, there was urgency. Could they not?
Quite possibly. However, it is submitted that the respondent is of the view that this is not sufficient. The telephone operator has received many of these calls before, and a new prank is easily available to the two youngsters.
They didn't know that at the time, though, did they?
That this was not a new prank?
Yes.
Submitted that based off the facts, that is exactly what they assumed it to be. They were not interested in providing their services.
Do you think this court is safe to deal with assumptions?
Assumptions on their own, it's a dangerous game. However,
Isn't it just?
absolutely. However, when dealing with assumptions as foreseeability, proving things on a balance of probabilities as we would, submitted that it would be safe to say that on a balance of probabilities, the phone operator in that moment believed the Crays were playing yet just another iteration of their well-established.
Are we
prank.
dealing with balance of probabilities?
Absolutely. This is a civil claim.
In respect of the assumption there, from what you're saying, this service then doesn't, you would expect if you call this service that they would provide you assistance, because it would appear objectively that they have assumed that role to offer service and assistance to anyone in trouble. So I'm a bit kind of confused as to how you can say they haven't taken on that assumption, because that would kind of suggest that you can ring them and it's kind of pot luck as to whether or not they choose to respond to your call or not.
Yes, Your Ladyship, thank you for the question. In addressing the assumption of responsibility, simply picking up the phone as the phone operator would not, in effect, create a duty of care between the respondent and the appellant in this case. The reason being that if this court is to consider the ramification that if every phone call made to 999 was to with it bring a duty of care, that the operator and the service which they represent now owe that caller a duty of care, this would, quote unquote, open the floodgates to an infinite amount of negligence claims against public authorities which are designed to help the public.
So at what point would you suggest in that case they would assume that responsibility, that duty of care? Does there come a point when you would concede that they assume that duty of care?
It is submitted that that point would come when a response time is offered and an assurance of response in and of itself and help is on its way. On the facts, it can be observed that such assurances were not provided by the phone operator.
Well, what if we find that there was an assurance by their very nature of how their phrase? There would be an assurance, wouldn't there?
Apologies, Your Ladyship. That
The comment is ambiguous, isn't it? And it's open to two forms of interpretation. Either because you've made so many pranks before, I'm paraphrasing, we're not going to be sending one. But equally, given that we've sent them previously, we're going to be sending one. So perhaps move on to a second point.
Your Ladyship, if I may quickly.
Yes, you may.
The interpretation of what the phone operator's comments to the Crays was to mean is a is a situation of interpretation.
It is, yes.
And in the court, it is submitted that we are required to take words in context with the words around them and in finding relevant meaning from that context.
So you say that they didn't assume the duty of care because they weren't concerned?
Precisely.
Yes, all right.
Please, your Lord and Ladyship, I'll now begin my second submission.
Yes, thank you.
May I direct your attention to the case of Robinson and Chief Constable, West Yorkshire Police, located page 64 of the respondent's bundle.
Yes, just bear with us a moment.
Absolutely.
Yes.
Sorry, can you remind me how
Sorry.
page, please?
Page 64, the respondent's bundle, cases Robinson and Chief Constable, West Yorkshire Police.
Thank you.
And your Lord and Ladyship's care for a summary of the facts.
No, I don't think so. No, thank you.
Case of Robinson addresses potential confusion provided by Michael. Now, as is the main submission of the respondent, that Michael is the correct law, which this court need follow in dismissing the appeal today, Robinson provides any clarification for supposition that a duty of care may have existed. In considering the court's finding in Robinson, a strong distinguishment was made between positive acts and omissions. The principle provided in Robinson, in its simplest form, is that the police and public authorities will not be subject to a duty of care in private law to individual citizens unless they are the ones themselves which have created the harm through negligent behavior. In the current case, it is the appellant who has climbed the mountain on his own accord and has created the own dangerous situation that they find themselves in. Now, while it is no doubt unfortunate, his actions do not create a duty of care between the respondent and the appellant today. Considering that Euphamra did not create the harm which the appellant finds himself in, this court cannot consider that a duty of care has occurred. Now, in specific, Robinson speaks of positive acts, as mentioned. In order for a police officer or a member of a public authority to create a situation which may in fact harm a potential claimant, that would require a positive act, as Lord Reed has so specified in his case digest.
But didn't the court below us make such a finding? Weren't they satisfied?
In the case of Robinson,
Oh, in this case, given the success.
that they were satisfied that the positive act had occurred.
Yeah, were they or not?
Apologies, Your Ladyship, I believe you are mistaken.
No, I probably got that wrong, so carry on.
Thank you.
This case does deal with police officers again, though, doesn't it?
Correct.
Carry on.
To quickly touch on the police officers, in the case of Michael, my first submission, it'll be found on page 41 of the bundle, which will be page 1604 of the law report.
Just bear with us a moment.
Absolutely.
Which paragraph?
Paragraph 115.
Yes.
In addressing her ladyship's comment that now we have two submissions dealing with police officers and the issue at hand is the amount
I'm
of
not
rescue.
sure we give submissions.
My apologies.
That's okay.
In addressing the ladyship's intervention, police officers are to be treated as equivalents to public authorities which find their nature of operation in helping the public. Such a standing can be found in paragraph 115.
All right, let's just bear with us a moment while we read it.
Absolutely.
Yes?
Submitted that the nature of claims will likely more often be found to be with police officers in terms of the courts determining where a duty of care will begin and where it does not exist. Is the inherent nature of the police officer's job that he will interact with the public more than a fire brigade.
Where will we assist us with this if you can? Where do we find the statutory definition of the services provided in this case? Do you know?
specifically to fire brigade and mountain rescue operations.
Yes. If you don't know, it's absolutely fine. You can perhaps look at it afterwards and let us know. I just wondered if you knew what the definition of that service was that they provided.
Well, your ladyship, it is the Fire Protections Act 1974,
Yes.
which will dictate the fire brigade's operations.
I'm not asking about I'm asking about the specific mountain rescue.
I would have to get back to you on that.
All right. So, because is that not important? In order for us to agree with you and the differentiation, will we not need to know the exact nature of that service that's provided and the expectation?
Submitted that simply based off the association's name, it is the Fire and Mountain Rescue Association.
And isn't that the important bit?
Absolutely, they operate in both realms.
Yes, but how can you separate them?
Submitted that they operate with the same level of responsibility.
How do you know that if you're not assisting us with what their actual role is? How can we be satisfied that it is different to an ambulance service, or it's the same as an ambulance service?
It is to be interpreted in the language of both Lord Tulson's and Lord Reed's case summaries for the case of Michael.
But only in terms of fire service.
Specifically for fire service, this will be touched on in the case of Capital and Counties PLC.
And mountain rescue?
They are not a mountain rescue, no.
Right, so help us with where the authority is that you seek to rely on that specifically deals with mountain rescue.
Well, there's no authority that directly touches on the occupation of mountain rescue.
Right,
In the case of the Uppenvonshire County,
yes.
it is submitted that the fire and mountain rescue are one and the same. They operate together out of a necessity.
Can you take us to that?
Unfortunately, that is not available in the case facts. That is to be determined.
Right, okay, carry on.
Absolutely. Please, your Lord and Ladyship, I can now move on to my third submission.
Yes.
Direct your Lord and Ladyship's attention to the case of Capital and Counters PLC, Hampshire County Council. Would your Lord and Ladyship care for a summary of the facts? And my apologies, the case is located on page 164 of the respondent's bundle.
All right, so just give us a moment. I don't think we need the facts one. Somebody. That's fine.
In revisiting,
Sorry, bear with me.
not a problem.
164.
Sorry, just 64.
Oh, 64, I'm sorry. I thought you said 164, that's my fault. Oh,
Oh, your Lords and Ladyships, I apologize. Seems my papers are out of order.
don't worry.
Case is located on page 107 of the
107.
respondent's bundle. We will get there in the
It's
end.
fine. There we go, yes. All right. And which paragraph would you like us to look at?
In specific, page 133, while there are no paragraphs, it'll be at the top of the page in line with a highlighted portion for your attention.
133.
Yep.
It's 1030.
Yeah.
And it'll be line A.
Paragraph A.
Correct. Now, in short, if I may, due to time restrictions of the submission, it need be argued that while the appellant has correctly identified the principle in the case of Capital Counties, they have incorrectly applied it to the case at hand. Counties tells the court, now while this case is not binding on us, it is highly educational, and it provides that a positive act is required for a duty of care to be established in establishing a claim in negligence. Now, by no means can it be said that the phone operator for UFAMRA 999 acted in a positive manner. In fact, it was a clear omission in which this phone operator chose to not dispatch the rescue services. As such, there can be said to be no positive act on behalf of the respondent, and no duty of care will exist.
Sorry, it's a choice not to dispatch, not a positive action.
Considering the two possible outcomes, Your Lordship, in receiving the 999 call, the request for aid, ultimately, the dispatcher will be left with the choice to either provide the services or to not provide the services.
Apologies, that's my technology.
Yes, Your Ladyship.
On that point, can I just ask then, who did finally dispatch them? Because we know that they were dispatched.
While it's not clearly outlined in the case facts, Your Ladyship, they were dispatched after 4 hours and several calls. This is the extent of the facts that the court has been given today.
And just lastly, and I'll be quick, I'm sorry. Can you just reconcile for me, and this may be me just being stupid. In the case of Michael, on page 41, paragraph 115, it clearly says, there's no private law duty on the police to exercise reasonable care. It's consistent with the way in which the common law has been applied to other authorities, vested with powers or duty as a matter of public law for protection of the public. Is that not directly in contrast to capital, where they're saying there is no common law duty? So which are we to follow?
It's submitted that these two are not in contrast. The take-home message from capital is that a fire brigade does not establish a duty of care until they have acted in a positive manner themselves, which has intervened with the link in the chain, so to speak. And it is only when they have acted in such a positive manner that it will be said that a duty of care then exists.
So that right, so their duty of care, right,
This is in following.
is triggered at the point that they attend the scene, for example.
If reading capital closely, Your Ladyship, it is actually submitted that even when attending the scene, a duty of care is still not present. It is only when the fire brigade will act in a manner which has conclusively changed the course of events. An act, a novus actus intervenus, if you will. In conclusion, for the reasons outlined, it is respectfully requested this court dismiss this appeal today.
Thank you.
Unless I may aid your Lord and Ladyship further. I don't see
No,
any-
thank you very much. Thank you.
On behalf of our patronship Fire and Mountain Rescue, referred to as UFAMRA, I shall be providing the second ground of response to this appeal. It is submitted that the court was correct to conclude that both Peter's relationship with Marshall and his psychiatric injury were too remote for a claim of negligence when applying Alcock. The decision of the previous court, the Court of Appeal, should be upheld. If it pleases your Lord and Ladyship, I shall now begin my first submission.
Yes, thank you.
It is submitted that Peter's relationship with Marshall was too remote for a negligence claim because the relationship was not one of a close tie of love and affection. For a claim to be successful, a relationship such as this is necessary. It is not plausible to assume that Peter and Marshall's relationship was one of a close tie of love and affection simply because they were childhood friends. Their relationship does not meet the category set out to fulfil this kind of relationship.
Well, it was more than just childhood friends. When one looks at the facts of this case, they're 19 years old, so they're not little boys anymore. So they've been friends since they were born. They've pretty much been brought up together. Their parents were very close, and they've been described as being inseparable, like brothers. How do you say that it's inconceivable that they could be seen to be having a very close connection?
Your Ladyship, it is something that I will move to later in this submission.
All right.
However, it would be noted that they are only friends still, despite knowing each other for a long time. They are not blood relatives. We can be close with someone, but still not be close enough to fulfil the criteria of a close tie of love and affection.
Or we can be blood relatives and not be close.
This is true, Your
What more
Ladyship.
do you think they would have to do then in order to not be blood relatives, but to be considered to have such close relationship that it would satisfy the text? What more do you think they needed to do?
Your Ladyship, it would be suggested that they may need to have some sort of physical tie, maybe owning a house or having some sort of investment, something that they've joined together with, instead of simply being friends with each other.
But
Because
a divorced couple can own a house together.
your ladyship, is a divorce. When a divorce occurs, is the house not split into two sections and they own half each?
No. It could be the husband lives in the house, the wife lives in America, they're divorced. They have no actual connection anymore other than owning a house.
This is true, your ladyship. However, it is submitted that, given the facts of the case, it is more necessary that a spousal relationship or a parent-child relationship be needed to bring a successful claim.
And is that backed up in your authorities?
Yes, it is, your ladyship.
Are you going to come
This,
to
I
them?
will come to this in the next
We'll stop
We
interrupting.
don't have patience. Carry on.
Thank you. Would your Lord and Ladyship care for a summary of the facts of the case of Alcock?
No.
Okay.
No, thank you.
The highlighted section from page 156 of the respondent bundle
Alright, just give us a moment. Sorry, I'm really slow. I don't know I need to learn how to just go to it, don't
Sorry, could I get that reference again?
page 156 of the respondent bundle.
I? Yes, thank you. Carry on.
This highlighted section indicates that a close tie of love and affection is the type of relationship presumed between spouses and parent-child relationships. Since this does not apply to Peter and Marshall, we must assess this relationship individually. From this section, we can see that one must assess the closeness of which needs to be proved on each case. One needs to be proved individually. Now, we must assess the criteria and its lack of reasonable application. The categories, as set out in Alcock, can be found on page 165 of the respondent bundle.
Just before we move on, and I'm sorry, it might be me being terribly thick as always, page 156, paragraph B, is that what we're looking at?
Yes, the highlighted section.
Does that not say not limited by reference to particular relationships such as husband and wife?
It does, your ladyship. However, if you look further, as we move now on page 165,
Yes,
to the criteria to fulfil this,
yes, sorry.
these criteria will not be fulfilled, therefore
All right, let's
the
go to
close tie of love and
165,
affection will
let's
exist.
go, yes.
The
Yes.
categories,
Which paragraph, sorry?
page 165, it will be the highlighted section.
Which paragraph?
Your ladyship.
Paragraph E.
Thank you. It sets out three sections which can allow a relationship to be sufficient for a claim to succeed as a close tie of love and affection. These categories are used to understand whether one's relationship is sufficient enough to allow psychiatric harm claims in negligence. Firstly, you must look to the fate of the loved one. Since Marshall emerged from the rocks unharmed, Peter cannot bring a claim over the fate of Marshall. You would need the tragic events of a death to occur in order for Peter to say he suffered psychiatric harm due to the fate of someone whom he had a close tie of love and affection with. This does not happen.
So are you saying if I were to read this correctly, well, you're inviting us to do so, that it is only when there is someone who's died that you can claim for psychiatric harm?
It is submitted, your ladyship, that is for that category, that would be true. However, if you look at other categories,
I don't understand, sorry.
so in Alcock, I believe it was Justice Hidden, suggests three categories. It would be the fate of the loved one, the relationship to the loved one, and the
Yes.
medium in which you perceive events. Peter cannot bring a claim based on the fate of the loved one, and I shall move to the other two categories as to how he cannot bring a claim later.
Yeah.
The second category looks to their relationship to the loved one. We cannot say that Peter and Marshall had a close enough relationship to claim for psychiatric harm. When looking deeper into this category, Justice Hidden refers to the category exclusively as spouse and or parent. As said earlier, Peter and Marshall do not have this relationship, meaning,
Sorry, yes, so carry on, sorry.
so meaning a claim would be difficult anyway. Therefore, we must look to the existence of the close tie of love and affection.
Yes.
It is not enough to say that just because Peter and Marshall were childhood friends, they had such a relationship. This would be to say that we all have relationships such as this with people we knew when we were young. Furthermore, given the fact that they live in a small area where almost everyone knows everyone, it becomes ever less likely that this relationship was sufficient to claim in psychiatric harm.
Are you, just because everyone knows everyone, why do you say that it becomes ever less?
Your Ladyship, it becomes ever less important because if everyone knows everyone,
Yes.
we would be opening this claim to everyone
But
that
they're not
knew
all
Marshall.
inseparable though, are they? You're not
No.
saying the entire village is inseparable, are you?
No, Your
Just
Ladyship,
because they
I'm
know
not
each
saying
other.
that.
I mean, that's the nature of a village, isn't it? People
Yes,
know
Your
each other,
Ladyship, it is.
know everyone's business. Sorry, carry on.
Allowing this relationship to be seen as one of a close tie of love and affection would allow everyone in the area to argue the same thing, that they knew Marshall. Most people knew Marshall in the same or similar way than Peter did due to the nature of being in such a small environment. The relationship, given the facts of the case, must be one of spouses or a parent-child relationship. The third category set out in Alcock is the medium in which you perceive events. Whilst this is the strongest category to support Peter's claim, it is still not enough as Marshall was never harmed. We cannot say that Peter saw or heard anything sufficient to cause him psychiatric harm. You may argue that the screaming or the supposed blood would allow for the claim to succeed, but we cannot allow for psychiatric harm claims in negligence to succeed every time someone sees a bit of blood or hears a scream.
But in this case, we know that he wasn't injured. It was an event that took place over 4 hours, with a friend waiting, not knowing what was happening under those rocks. We don't know where that blood came from, but we can only read on it that he thought it was his friend. But what we do know is that he has been diagnosed with a psychiatric illness, hasn't he?
Yes, Your Ladyship, he has.
Right, and are you saying that the psychiatric illness was caused by something else, other than witnessing his friend in that, whatever happened that day?
Your Ladyship, the psychiatric illness may be caused by Marshall's screams, which are not definitely due, which are most likely not due to pain.
Are you
It could
going
be a
behind the
further crime.
psychiatric assessment?
Your Ladyship, could you please rephrase the question?
Do you seek to argue against the psychiatric diagnosis?
No, Your Ladyship, it is undeniable that
Yeah.
Peter has suffered psychiatric illness. However, if it is suffered due to Marshall's screams, which we cannot attribute to any harm, then it is plausible that his psychiatric illness comes from maybe a further prank by Marshall and not any sort of relationship between the two.
Alright, take us to the evidence of that, please.
Your Ladyship, what evidence would you be looking for?
What evidence that it's plausible that it might be some other prank?
Well, given the fact, Your Ladyship, that Marshall suffers no harm, there would be no need for him to be screaming.
Did the authorities not say there doesn't need to be harm for the first person, it's the perception of the harm for that secondary person? Have I misunderstood that?
Your Ladyship, I believe that whilst it's true that it would come down to perception potentially, if Peter has misperceived the events, we cannot allow him to bring a claim for something he's misperceived. He can definitely suffer psychiatric illness from misperception, but he cannot claim damages for that.
Alright, carry on.
If it pleases your Lord and Ladyship, I shall now begin my second submission.
Yes, go ahead.
Drawing again from the case of Alcock, it is submitted that Peter's psychiatric injury was too remote for a claim in negligence because he was nothing more than a mere bystander to the events. Peter did not have any real involvement in the accident to elevate his position above this. He cannot be considered a rescuer because this categorisation cannot become applicable to everyone involved. Also, for a mere bystander to have a successful claim, they must witness something sufficiently horrific. Given Marshall's lack of injury, this cannot be said to have happened.
What about the fact that his friend was buried under rocks for 4 hours?
Your Ladyship,
Regardless of the injury or not.
this could be seen as horrific, however, as later I will compare to the example given, I believe, by Lord Ackner in Alcock, it is not sufficiently horrific of an event to bring a claim. Firstly, we shall consider Peter as a rescuer. A rescuer can be considered someone who seeks to assist and help those injured in an accident.
Can you take us to where that base in the authority is about what identifies a rescuer?
Your Ladyship, rescuer is often referred to throughout Alcock, however there is no definition given, so it is mere
Are you inviting us to consider that that's a definition of rescue?
I'm inviting you to accept that as the definition, yes, Your Ladyship.
All right, thank you.
On this definition, Peter could be considered a rescuer because he made a phone call to the emergency services for help. However, being legally classified as a rescuer to the degree where a claim in psychiatric harm is successful is not as easy. On page 179 of the respondent bundle, you can see Justice
Just
Hidden
bear
talk
us
of
as a
this
moment.
principle.
Thank you.
Sorry, which page?
179.
Thank you.
Is that paragraph D?
It will be the highlighted section, yes.
All right.
Justice Hidden can be quoted saying that we have to consider whether and how far it may be applied. We can see concern here from Justice Hidden about the extent of use and variety of claims the principle of rescuer opens. It is precisely the idea of someone in Peter's position claiming to be a rescuer that Justice Hidden is trying to avoid. To be seen as a rescuer, Peter would have had to help remove Marshall from under the rocks or tend to any wounds. The mere placing of a phone call is not enough to constitute Peter being seen as a rescuer. If Peter cannot be classed as a rescuer, he must be seen as a mere bystander. The principle of mere bystander to events can be seen on page 204 of the respondent bundle.
Right, just pause, just a moment, just before we move on, just bear with me a moment, please. Just looking at the previous paragraphs, and then looking have you got your authority there?
As in to be able to read?
Yeah.
No, Your Ladyship, I don't.
Because just bear with me a second, I'm just going to confer with the other judges. What I'm just trying to work out, because the temptation is to pick out just a section that it underpins your argument, but it does seem to us when one looks at the case law, when one looks in the paragraph above and below, and I don't. It's really tricky, because I'm not trying to trick you at all, but it would seem that my reading is. There needs to be an extension. Then you need to look at it in a bit of a wider picture. Would you accept that? You can't just look at it in that narrow form. That seems to be what the judge is saying.
Are you referring to deciding if Peter would be seen as a rescuer or not? The idea of a rescuer, I believe, is purposely a narrow principle, because if we allowed everyone to be a rescuer, you would be allowing everyone from the placing of a for example, if someone places a phone call as Peter does, I do not believe they can be attributed to be rescuing Peter, because they've not really done anything to help. They've informed people that Marshall would be injured, but they've done nothing further than that. And if we opened the principle of a rescuer to every single person that was involved, you could lead to hundreds of people bringing a claim for one accident, which would be unfair to bring damages to all those people for the defendant.
All right, thank you. And sorry, you'd moved on to what page?
204, the principle of a mere bystander.
Thank you. Yes, sorry about that.
It may be quoted that even a bystander, if the scene is sufficiently horrific, can claim for psychiatric harm. It is this wording of sufficiently horrific which I want to discuss. Whilst it's undeniable that Peter was a bystander to the events, we cannot say with certainty that the events were sufficiently horrific. Once again, I may point to Marshall's lack of injury to demonstrate the absence of sufficiently horrific events.
Is there a definition of sufficiently horrific within the judgment?
I do not believe there is, your ladyship. It is on page 24, they just refer to sufficiently horrific events, and I don't know exactly where, but Lord Acton will, as I will go to explain, give an example of a sufficiently horrific event.
All right, so perhaps, are you going to
I'm
address
about to
that? All right,
present that now.
okay.
The comparison that Lord Ackner would give would be the example of a petrol tanker crashing into a school.
And where is that? Sorry to interrupt. Where is
Your
that?
ladyship, given the largeness of the case, I'm unaware where the example actually is, but it is an example given by Lord Ackner.
Well, I just wondered exactly where it is in the judgment, because it's fine, if you can't take us to it, we can look at it afterwards, that's fine.
I mean, the papers are there if it would assist you, if you know whereabouts in the judgment it might be.
Your ladyship, unfortunately, that would not aid.
Yeah, okay.
For a mere bystander to witness such events as this tanker crashing into a school, this would be enough to claim for psychiatric harm as a mere bystander. I do not believe that the events Peter witnesses are comparable to the events suggested by Lord Ackner. Some may think that he gives an extreme example, but it is the example given. Therefore, we must compare any claim of a bystander to this example.
So that one example,
Yes, your ladyship, since it is the example given in the authority.
but you're not surely suggesting that we simply narrow ourselves to that one example and then apply the facts of every case to that one example, are you?
Your ladyship, no, we would not use
No.
just this example. However, it is the severity of the example which we would look to. I do not
What
believe.
about a parent who sees their child run over? As one parent,
Yes.
one child. But if you apply it to that example, it doesn't go anywhere near enough.
Your ladyship, I believe a parent watching their child be run over would be sufficiently horrific.
But not if we apply the example you're giving.
To assist my ladies, the example is on page 403 of the bundle.
403.
403.
Thank you. All right, carry on. Thanks. Carry on.
Justice Hidden can be quoted as saying defendants cannot be expected to compensate the world at large. This references the narrow and high threshold for bystanders trying to bring a claim. A defendant cannot compensate everyone who was involved, everyone who witnessed, and everyone who heard about the events. If it pleases your Lord and Ladyship, I shall now briefly begin my third submission,
Yes.
given the lack of time we have.
Yes, I'm sorry, we've been asking lots of questions, so carry on.
It's submitted that Peter's psychiatric harm was too remote because it was not reasonably foreseeable that he would suffer such harm. Given the emergency services euphemeria could not foresee the seriousness of the call due to Peter's history of prank calls, especially given the striking similarity between his pranks and that of this call. This principle of reasonable foreseeability is first seen in the Wagon Mound number 1 case on page 308 of the bundle. Would your Lord and Ladyship care for a summary of the facts?
No, thank you.
We can start by saying that it was not reasonably foreseeable that Peter's call was serious. On 10 separate occasions, Peter had caused calls from tourists with some incident requiring emergency services, and on those 10 occasions, the emergency services arrived to find that they had again been pranked by Peter and Marshall. The facts of those here are that of the boy who cried wolf. The meaning behind this story is that when you repeatedly lie, your truths become less believable. The reasonable man will immediately respond to emergency calls. When you get the same call over and over again and they keep on being fake, it is reasonable to assume that these calls are no longer emergencies.
But they didn't. This was the first call they made though, wasn't it?
Yes, Your Ladyship, which is why no emergency services were sent.
No. This is the first call that the boys had made, because previously it was the public, wasn't it?
Yes, so despite this being the first call the boys had made,
Yeah.
given when the emergency services attended to the scene, they would have been aware that the pranksters were Peter and Marshall.
Yeah.
So I believe the fact is it is almost irrelevant if Peter and Marshall made the call
All right, so
or
you're
caused
inviting
the
us to
call.
say it's relevant, yeah. Okay.
Yes. It would be fair to say that the emergency services should respond to all calls, but given the similarity of the facts between the prank and the facts of the case at hand, it's reasonable that the operator assumed this to be another prank. whilst the harsh reality, Peter and Marshall's behaviour and lack of respect for authorities has brought this upon themselves. It's also not reasonably foreseeable that there would be any injury to attend to for similar reasons. The recent prank was so similar to the current facts that the emergency services could not reasonably anticipate any real threat of danger to Marshall. Upon hearing Peter's calls for help on the phone, no reasonable person would actually believe that someone may be in danger. It is again a sad reality that Peter and Marshall have created this situation for themselves.
So, because they've done previously, it serves them right.
Your Ladyship, yes, but this is more when you consider the fact that Marshall was unharmed. They've brought this scary situation upon themselves. It is their own fault.
All right.
So if Marshall had been harmed,
If Marshall had been harmed, then potentially their claim would be successful. But since Marshall is unharmed, they cannot be a successful
but if
claim.
Marshall had been harmed, that wouldn't have altered the reasonable foreseeability of that call handler, would it?
Your Ladyship, no, but I think we have to consider the fact that Marshall was unharmed. It's an unescapable fact that will alter on the foreseeability of sending emergency services.
I just want to, sorry, finish your submissions and I'll come back to this point, I think, sorry.
Peter cannot claim against the emergency services for his psychiatric harm because it is attributed to his own poor behaviour. The accident even occurred during practice for another prank, meaning that Peter was putting himself in the path of suffering such harm. No reasonable man could foresee this. To conclude, we the respondents respectfully request you uphold the decision of the Court of Appeal. Firstly, by seeing that Euphamra owed no specific duty of care to Peter, and secondly, because Peter's relationship with Marshall and his psychiatric injury were too remote from the accident to bring a successful claim. Unless I may aid the Court further, this concludes my submissions on behalf of the junior respondent.
Yes, just bear with me a second, I'm really sorry. I'm just troubled about the stance by the respondents that there has to be relatives
How do you
in
mean relatives?
proximity.
In what do you mean relatives as in the spouse or parent-child
The
relationship?
nature of the relationship.
The
Yeah.
nature of the
to the
relationship.
claimant.
Just bear with me a moment. Sorry, it's a really long judgment, I appreciate it. I just tried to scroll back to the top. Okay, no, I won't scroll back up, but I'm just looking at, and I appreciate you haven't got it in front of you.
Yes.
Oh, you have got it now. So,
Yes, that's the section.
Yeah.
okay, if you look at, oh, sorry, did you give yours? Sorry. I'm just going to read out, and I appreciate I'm doing what you do, all of you, understandably, is picking out the bits you want, but looking at page 249, I'm going to go back to it, sorry.
You may not be on the correct page.
So it's internal page 404, 249. Was it 249? Let me find it. I lost it myself now. I might have lost it. I might just have to come back to you when we've finished.
Isn't the first submission?
No, I'll come back to it when it's over. I'll come back to it. Thank you. No, that's. I don't think we've got any other questions for you. No, thank you very much.
Thank you, Your Lord and Ladyships.
So now we have the appellants who can go outside and deliberate for 3 minutes and decide if they would like to exercise their right to respond.
This is what I was saying. Find it.
Just at your discretion. You are mistress of the moot. So, thank you everyone for attending tonight. Just wanted to let everyone know what a right to response is in terms of the mooting context. So we have our appellants who will have the right to respond to the submissions of the respondents here. So they can respond on only what they have submitted, not on what was presented during the interventions by our judges over here. So they can only address and try to rebut some of those points, but they cannot refer to their own submissions in this rebuttal. In case you did not hear that, it is 2 minutes in case you choose to exercise.
Thank you. It is submitted in a rebuttal to the respondents' points that in relation to the lead respondent's second submission, where that an act nor omission played no active part to contributing or creating the situation that Mr. Wolf found himself in, is inaccurate. While the mountain service did not create the danger, they did actively contribute to it by extending the period of time that the situation went on in the delay of the ambulance. And then in relation to the junior submissions, none of the quotations provided by the junior respondent are legally binding in terms of that they were either from the High Court, the Court of Appeal, or the Privy Council.
We can still apply them, right?
They're persuasive but not binding.
Yeah.
And in his reference to Alcock being a House of Lords case, his quotations were only taken from the High Court or the Court of Appeal. The Wagamount being a Privy Council case, as well as, again, persuasive but not binding. And then one of the quotations provided from Alcock was actually a quotation from the case of McLaughlin. And then all the quotations that were not attributed to Lord Ackner are not binding, and Justice Hidden presided over the case in the High Court, and Lord Justice Parker presided over the case in the Court of Appeals. So while the quotations are persuasive, they don't follow the highest authority, given that the Alcock case was from the House of Lords. And that concludes the rebuttal on behalf of the appellants.
Thank you very much. Thank you. We're going to go and think about all the very good submissions.
All rise. So Olivia will lead you to the do you have any assistance with Karen? No. All right, perfect. Olivia will guide you. As for everyone else, time for some refreshments in the next room over.
Well done both.
Excellent job. Will? Very good.
Sorry, ma'am.
Long hard, and the conclusion that we have reached is the appeal is successful in part. Before you smile too brightly. So we found that there was a duty of care, and we found that the service was negligent, but what we didn't find was that there was sufficient for damages. So we found that there was a close relationship, there was a close proximity, but we were persuaded by the argument that the injury was too remote for us to award damages. So I'm afraid it's we giveth with one hand and we taketh with the other. So that is the order of the court. And then we come to what was actually much harder. You were all brilliant. Right, so Olivia, I blame Olivia because she said you can be as mean as you like. So really, you were all brilliant. So, and and actually, if we had 4, we would say 4 equally, but we can't. So the 2 winners, we would say, and again, I promise you, it was really finely balanced because you're all brilliant. Was lead counsel for the appellants and lead counsel for the respondents, but you were all amazing, really, really amazing. So we thought, I think you're going to turn. Are you going to turn off the?
If it's come to the feedback.
Yeah, we thought a little bit of feedback. If that's okay, it's been a really long night. I just wanted to go to the front. We'll quickly give some quick feedback. Oh.